Bringing Your Family to the USA, A Guide to Family Visas. Written by Ilona Bray from Nolo Press. Reuniting with loved ones is a dream shared by many. This guide is here to help you navigate the process of bringing your family to the United States through a family visa. We'll break down each step, making it clear and easy to understand. Our goal is to provide you with the knowledge and confidence to successfully navigate the application. Who can come to America? Understanding eligibility. Before starting the application process, it's crucial to determine who is eligible for a family visa. The U.S. immigration system prioritizes immediate family members of U.S. citizens and, to a lesser extent, lawful permanent residents, or green card holders. Immediate relatives of U.S. citizens include spouses, unmarried children under 21 years old, and parents if the U.S. citizen is 21 years or older. Eligibility for other family members like siblings or married children is more limited and depends on various factors, including quotas and backlogs. Carefully reviewing the eligibility criteria on the U.S. Citizenship and Immigration Services or USCIS website will ensure you meet the necessary requirements. Choosing the right path. Different types of family visas. The United States offers different types of family visas, each with its own set of requirements and processing times. Understanding these options can be overwhelming, but it's essential to choose the right path for your family's needs. Choosing the correct visa category is crucial for a successful application. Each visa type has specific eligibility criteria, and selecting the wrong one can lead to delays or even denials. The most common types include immediate relative visas, or IR. These visas are designed for the closest family members of U.S. citizens. These visas are for spouses, unmarried children under 21, and parents of U.S. citizens. They offer a direct path to reunification without the lengthy wait times associated with other visa categories. There is no annual limit on these visas, making them a preferred choice for many families seeking to reunite quickly. Family Preference Visas, or F, are for other family members of U.S. citizens and certain relatives of green card holders. These visas cover a broader range of family relationships. However, these visas have annual limits which can lead to longer processing times. The wait can be challenging, but understanding the process can help manage expectations. Consulting with an experienced immigration attorney can help you determine the most appropriate visa category based on your specific family relationship and circumstances. An attorney can guide you through the complexities of the application process, ensuring that all necessary documentation is correctly submitted and that you are fully prepared for any interviews or additional requirements. Ultimately, the goal is to bring families together, and understanding the different types of family visas is the first step in making that happen. With the right information and support, you can navigate the immigration system successfully and look forward to a joyful reunion with your loved ones. The first step, filing the petition, Form 1130. The journey to reunite with your family begins with filing Form 1130, Petition for Alien Relative with USCIS. This petition establishes the legitimacy of your relationship with the family member you wish to sponsor. Form I-130 requires specific information about both you, the petitioner, and your relative, the beneficiary. This includes full names, dates of birth and addresses, information about any previous marriages, proof of U.S. citizenship or lawful permanent residency, and evidence of your familial relationship, such as birth certificates or marriage certificates. Accuracy and completeness are vital when filling out Form 1130, as any discrepancies or missing information can lead to delays or denials. Proving your support. Financial requirements. Form 1864. The U.S. government wants to ensure that immigrants will not become financially dependent on the state. This is a crucial step in the immigration process, as it helps to maintain the economic stability of both the immigrant and the country. Therefore, you, the sponsoring relative, must demonstrate your ability to financially support your family member once they arrive in the U.S. This responsibility is significant and requires careful planning and documentation. This is done by submitting Form 1864, Affidavit of Support. This form is a legally binding contract between you and the U.S. government, affirming your commitment to support the immigrant. Form I-864 requires you to provide proof of income, such as tax returns and pay stubs. These documents help to verify your financial stability and ability to support the immigrant. Additionally, you must provide information about your assets and liabilities. This includes bank statements, property ownership documents, and any other financial assets you may have. You will also need to provide details about the size of your household. This includes everyone living in your home, as the number of people you support affects the income requirement. Your income must meet a minimum income requirement, which varies depending on the size of your household and the state where you reside. This ensures that you have sufficient resources to support the immigrant without financial strain. If your income alone is insufficient, you can use assets or secure a co-sponsor to meet the financial requirements. A co-sponsor is someone who agrees to share the financial responsibility, providing additional assurance to the government that the immigrant will be supported. Getting your documents in order, a checklist for success. The Family Visa application process requires extensive documentation. This can often feel overwhelming, but with the right preparation, it becomes manageable. Gathering all necessary documents before starting the application can save time and prevent avoidable delays. It ensures that you have everything you need when you need it, reducing stress and making the process smoother. Here's a checklist of commonly required documents. These are the essentials that most applicants will need to provide. Birth certificates for all family members, marriage certificate if applicable. These documents establish your identity and familial relationships. Divorce decrees or death certificates for any previous spouses, passports for all applicants. These are crucial for verifying your marital history and travel records. Police certificates from all countries where applicants have lived, medical examination results. These documents ensure that you meet the health and security requirements. Financial documents like Form 1-864, tax returns, and bank statements. These prove that you can financially support your family members. Form I-130, petition for alien relative, and visa application fees. These are the official forms and payments required to process your application. Remember, each case is unique, and additional documents may be required. It's important to stay informed and be prepared for any additional requests. It's crucial to consult the USCIS website or an immigration attorney for a comprehensive list of required documents for your specific situation. They can provide guidance tailored to your case, ensuring you don't miss any critical paperwork. By following this checklist and seeking professional advice, you can navigate the family visa application process with confidence and ease. Proper preparation is the key to success.